Good afternoon, and thank you for joining us today. It's my privilege and pleasure to welcome you to the first lecture of our 2012-2013 Distinguished Lecture Series. This series is designed to bring in distinguished leaders and scholars to share with us their thoughts on the cutting-edge issues that will define our society in the years to come. And today's topic, privacy, and today's speaker, Professor Anita Allen, certainly fit within those parameters. Privacy is something I think that concerns all of us, especially in this internet and information age. It seems that every online photo, every disclosure made in an email or in the web media can be stored, and it can be brought out years later. Privacy is part of our individuality. Privacy is part of our identity. And we like to think that we can choose which parts of our lives ought to be shared with others. But I think you've all been in law school long enough to see that this is an evolving concept. If you think just of the common law cases you've studied in torts, you've seen an evolution in the attitudes of the judges over these hundreds of years of development, because you've seen cases where the judicial decisions and the opinions of the judges revealed a societal attitude and a view that it was patently unthinkable to share or disclose certain intimate acts, and patently unthinkable not to protect your bodily privacy. And then today, so-called reality television leaves nothing to the imagination and nothing privileged or private. Our distinguished speaker today, Professor Anita Allen, is the ideal person to guide us to a better understanding of the importance of privacy, what it means, and why it is so serious. In reviewing her 2011 Oxford University Press book titled Unpopular Privacy, What We Must Hide, Professor Paul Schwartz of the University of California, Berkeley Law School called Professor Allen our leading philosopher of privacy. Through her several books and countless articles, she has more than earned that title. A graduate of the New College with a master's degree and PhD from the University of Michigan and a JD from the Harvard Law School, Professor Allen is a person of many talents. A former deputy dean at the Penn Law School and a former associate dean at Georgetown Law, she is an acknowledged expert in privacy law, bioethics, and contemporary values, and also a valued scholar in the fields of legal philosophy, women's rights, and race relations. In addition to serving as the Henry R. Silverman Professor of Law and Professor of Philosophy at the University of Pennsylvania, she serves as a senior fellow in the bioethics department of the university's medical school, a faculty member in the university's African Studies department, and an affiliated faculty member in the university's Women's Studies program. She has written several books, a case book, and countless articles in law reviews and philosophy journals. As Professor Schwartz indicated, she is truly our leading philosopher and scholar in the field of privacy. It's my great privilege to introduce her. Please join me in welcoming Professor Anita Allen.
Thank you for that extremely kind introduction. I'm very happy to be here. I think that it's great to have an opportunity to see this beautiful campus and to congratulate you on your very good decision to go to law school and to become a lawyer. I have been around for a while, and I've been privileged to see a lot of change happening in our society, and some of it's very positive, some of it's not so positive. So for me, the overwhelmingly positive thing I've had the privilege of seeing is the way in which, from my childhood to the present day, we have grown as a country in the area of civil rights and civil liberties. And I think our President Barack Obama symbolizes the change, the positive changes that have happened in our country in terms of education, opportunity, and participation in politics. But there's one area where I think that the change that's happened, to me, is not so positive, and that's in the area of privacy, which your dean so nicely introduced for me, actually, the problem of a society that is moving toward an ethos in which disclosure is the norm, the default, rather than protection of privacy. So what I want to do today is to share with you my thoughts about the consequences and significance of the shift from privacy to disclosure. Okay, so that's going to be my talk today. And I was asked if I would contribute my talk to your law review, and I will indeed contribute the text. I may depart from the text from time to time, but you will have an article in your law review that reflects my considered judgments on these issues. So here I go. So we live, I would argue, in an era of personal revelation. We're preoccupied by gathering and seeking and disclosing information about ourselves and other people. We're fond of broadcasting what we know and think and do and feel, motivated by business and by pleasure because we care about friendship and kinship, health, education, politics, justice, and culture. A lot of this has to do with technology, of course. We live at a historical moment characterized by the wide availability of multiple modes of communication, easily and frequently accessed, capable of disclosing breadths and depths of personally identifiable and sensitive information to many people rapidly. When I came to Miami, I came with my cell phone, my iPad, and my laptop, right? 5 days I had to have all three technologies. On the beach yesterday, I had all three technologies going at one time. We are in this sort of mode of now of communication, rapid, broad, constantly. I'm going to give three examples from the past several years that to me illustrate the ethos of our revelatory era. And some of these examples, you'll be very familiar with, some you might not be so familiar with. So here's the first example. This is Joyce Maynard. When Joyce Maynard was only 18 years old, she had an intimate affair with the famed writer J.D. Salinger. He was 53. For a short while, the mismatched lovers lived together in his New Hampshire hideaway, to which his fame and genius seduced her. Then in 2006, Maynard, now fully adult, announced that she was going to sell the 14 unpublished love letters the reclusive Salinger wrote to her between April 1972 and August 1973. Sotheby's auction house agreed to manage the sale. Now, Maynard knew how greatly Salinger valued his privacy and that he would be offended by her decision. But she said the letters were her property and, moreover, that she needed the money in order to send her children to college. Besides, her own privacy didn't matter to her because she had already published a memoir called At Home in the World about this fascinating and scandalous affair. And she also wrote the book on the slide chronicling what it was like for her growing up in the 1960s. So the question that I want to ask is, was it ethical for Maynard to exploit the law and further offend and embarrass her former lover for profit? Is it self-evident or not that a person should not do what Maynard did? Is it her freedom that justifies her violating the privacy of someone else and so readily giving up her own privacy? My second and third examples involve contemporary communications technologies. About a year ago, I guess maybe 2 years ago now, this young man, Tyler Clementi, was a freshman at Rutgers State University of New Jersey. He asked his roommate, Darum Ravi, if he could have their room for the night for a date. Ravi consented, but then pulled a prank, now infamous prank. He concealed a webcam in the dorm room, and he webcast Clementi's same-sex intimacies all over the internet. When Clementi learned what had been done to him, the distraught gay youth bid farewell to his friends online and then committed suicide by jumping off the George Washington Bridge in New York City. Now, in my view, the ethics of Joyce Maynard's revelation about her affair is somewhat debatable, but the ethics of Ravi's is not. Ravi's thoughtless advantage-taking was unethical, and as moral luck would have it, it was also something that had a devastating outcome, compounding the sense of its wrongfulness. You won't be surprised to learn that Darum Ravi was criminally prosecuted in New Jersey for his role in prompting the death, and he was found guilty of crimes under New Jersey law. WikiLeaks. So this is the third example. WikiLeaks describes itself as a nonprofit media organization dedicated to bringing about important news and information before the public. And it does this by providing a secure and anonymous way for independent sources around the world to leak information to its journalists. And as you know, a couple of falls ago, a member of our government, a government employee, leaked a multitude of secret and confidential diplomatic missives to WikiLeaks. The sensitive documents were published by WikiLeaks and then republished by major mainstream media and social media alike. Many people were appalled that such a thing would occur. But strikingly, many people were not appalled. Why? Because they thought that maybe there is no legitimate expectation of privacy in a diplomatic mission. Or because they thought that, well, stuff got out, but security wasn't greatly threatened. Or because they believed that the social good of disclosure far outweighs any embarrassment to diplomats or to nations. What is the social good at issue? According to WikiLeaks, we publish material of ethical, political, and historical significance while keeping the identity of our sources anonymous, thus providing a universal way for revealing suppressed and censored injustices. So, disclosure, but maybe it's for the social good. Some of the commentators about WikiLeaks link, of course, the WikiLeaks episode to the democracy movements that broke out across North Africa. Nonetheless, some professors of foreign relations say they will not use the WikiLeaks documents in their classes because of the unethical way in which they came to be known. In the age of revelation, sensitive information will come to light, whether it's ought to or not. Our love lives, our political strategies will come to light. For better or for worse, everything from furtive street crimes to our genomes will come to light. So why does it matter? What's the value of privacy? What's being lost in all of this? Well, my focus is on informational privacy, and by that I mean to include conditions of limited access to and disclosure of personal data. A discussion of informational privacy would be expected to address questions about when to restrict publication of intimate facts and when to require confidentiality. Now, most of the foundational work about the ethics of privacy in the United States has been produced since the 1960s. I mean, remarkably, not until the 1960s did philosophers begin to think carefully and systematically about the value of privacy. But we do have now over 50 years of work. And in this work, which was prompted by the growth of computing and data banking, in this work, privacy is elevated to the status of a great value of enlightened civilization. This is in contrast to the way many technology theorists and internet scholars write about privacy. They're quite dismissive. They find it an annoying, irrelevant value. It's a dead, unwanted value about a useless thing, something that maybe our great-grandmothers cared about, but we should not. In fact, one of my colleagues at Penn recently bemoaned the fact that conversations about the internet security issue devolve, his word, devolve, into discussions about privacy. So why do the overwhelming majority of philosophers, academic philosophers, who write about privacy tend to praise it and to associate it with very important values? Let me just give you an idea of some of the values that are cited by philosophers to explain why privacy is important, which might explain why we should be cautious about our Facebook and our Twitter and our Foursquare. Self-expression. Opportunities for privacy allow individuals to better express their true personalities and values. Good reputation. Privacy helps protect reputations. Repose. Privacy enables tranquility and relaxation. Intellectual life. Privacy may enhance creativity and reflection, which may be good for their own sakes, but also which can lead to useful cultural products and inventions. Intimacy and formality. Opportunities for privacy are thought to enable individuals to keep some people at a distance so they can enjoy intense relationships with other people. Preferences and traditions. Privacy allows the individual or group of like-minded people to plan undertakings and to live in accordance with their own preferences and traditions. Civility. Privacy norms sustain civility by condemning behaviors that offend courtesy, honor, and appropriateness. Human dignity. Philosophers have said that respect for privacy is in many ways respect for human dignity itself. The list goes on. Limited government. Privacy rights against government demand that state power is limited and unobtrusive, as liberal democracy requires. Toleration. Privacy rights demand that government tolerate differences among individuals and groups. Autonomy. An aspect of liberty, privacy fosters the development and exercise of autonomy. And finally, individualism. Privacy fosters individualism, and it's not fairly condemned as a purely individualistic value because we, as individuals, can develop our capacity to become more cooperative and to make our community more efficient and welfare-oriented. So those are the kinds of lines of arguments and concepts that philosophers use to defend privacy. And it's quite at odds, again, with the current hipper discourse about privacy, where privacy is it's either dead or irrelevant. But I do think that we need sort of to join issue with these two sort of perspectives on privacy. Which one is right? Which one makes the most sense to us? Now, anybody who wants to make a case for privacy, of course, needs to understand that there are good reasons to limit privacy. National security. Sometimes privacy interferes with national security measures. Law enforcement. Sometimes privacy interferes with effective and efficient law enforcement. Public health. Sometimes privacy interferes with the effective and efficient public health protection. It impairs the delivery of routine medical care. Public right to know. Privacy does chill free speech and free press. Privacy keeps information the public has a right to know in private or government hands. And there are other values as well that seem to count against privacy. Sometimes it's administratively costly to protect privacy. Sometimes privacy does devolve into selfishness. Sometimes there might be, in some contexts, too many privacy rights at play that interfere with people's ability to get stuff done. And then sometimes, of course, privacy rights shield really offensive and dangerous conduct, domestic violence, internet defamation. And privacy, therefore, is not purely a good thing. And I want to say a little bit about the lure of free speech, because the lure of free speech is one of the things that makes privacy so difficult to defend in our society, right? Because we think that, well, people should be able to say what's true. It's true, isn't it? Why shouldn't we be able to say it, right? It may hurt people's feelings. It may be off color, but it's true. It's real. We have a right to talk about it. And we also have a right to a domain of life in which we can vent. When my students hear my case for privacy and my desire to keep the internet less offensive, they say things like, well, you know, Professor, we use the internet as a place we go to vent. If we didn't have this place to go to yell and scream and say off-colored things and be rude and be nasty and be mean girls and all that good stuff, then we'd have to do it in the real world. That would be worse. So isn't it a great thing? The internet provides a domain in which we can vent. But venting can go too far. And the courts have been asked to deal with internet speech that's gone too far, in my view. In a high-profile federal district case from the U.S. called Doe 1 and Doe 2 versus individuals whose true names are unknown, this is a 2008 case, the plaintiffs were two female students at Yale Law School. The two had been made targets of defamatory, threatening, and harassing statements posted on the website called AutoAdmit from 2005 to 2007. Now, AutoAdmit is an internet discussion board. Who's heard of it, AutoAdmit? Okay, it's an internet discussion board that in the mid-2000s drew between 800,000 and 1 million visitors per month. Right? Participants posted and reviewed comments about universities and law schools. Now, a photograph of one of the plaintiffs in this lawsuit was published on AutoAdmit without her permission. An anonymous commentator encouraged others to, I'm going to be a bit vulgar here, but I'm quoting, quote, rape this huge-breasted, cheerful, big-tit girl from Yale Law School, unquote. Okay? In nearly 2 months, 200 threads about the women were posted. One post stated the plaintiff fantasized about being raped by her father, that she enjoyed having sex while family members watched, that she encouraged others to punch her stomach while 7 months pregnant, and that she had a sexually transmitted disease, and that she had abused heroin. And one of the posters said, he hopes that she gets raped and dies. Free speech. After the plaintiffs filed a lawsuit, many of the posts were filed discussing the lawsuit, and many people took the side of the poster, anonymous poster, against the two women. Well, the Yale women brought federal copyright claims because of the publication of the picture. They also brought claims for libel, invasion of privacy, and emotional distress against this unknown person, in particular, who made the remarks that I quoted, who used the sort of secret name or code name, anonymous name, AK-47. So the women's lawyers issued a subpoena duces tecum to internet service provider AT&T for information relating to the identity of the person who was assigned to the IP address from which the individual AK-47 had posted his rude comments about one of the plaintiffs. And AT&T sent a letter to the person saying, you know, this has happened and we should file a motion to quash you. If you want a motion to quash, you know, you need to do this. So this is what happened. There was a motion to quash. In my view, the court got this exactly right. The court held the plaintiffs were entitled to the disclosure of identities of the poster's identity. He cannot hide behind anonymity. He has it's proper for the plaintiff to be able to use the subpoena to find out who this guy is and to hold him responsible for his defamation, invasion of privacy, and other wrongs. So the court stated that although the First Amendment does provide speech and does protect anonymous speech, it does not protect the right to commit civil wrongs online. Interestingly, the young man, who once he was uncloaked, he filed a motion to be able to proceed anonymously in the lawsuit, to be called John Doe and not by his real name. But the court said, sorry, that the privilege of appearing in a lawsuit anonymously is reserved when there are very, very strong reasons. It's a very, very exceptional right, and you don't deserve it here. So that's a very egregious example, shocking one, of someone taking away your privacy, right? And then having society decide whether free speech is more important than your privacy. But what is probably as concerning to me is voluntary self-disclosure, when we give away our privacy, when we just sort of don't care, and that's the sort of the Maynard Singer affair issue, where Miss Maynard just gives away her privacy; she doesn't care. And a lot of us give away our privacy every day on Facebook and Twitter and Foursquare. We tell people where we are on Foursquare. I'm at St. Thomas Law School, tweeting, giving a lecture at St. Thomas Law School, good-looking crowd. Facebook, the pictures, the location status, everything is there for public view. Your dean mentioned that reality television is part of sort of the new ethos of disclosure. We are a society of exhibitionists, and voyeurism pervades. Everything is on the line. People webcast their childbirth, they webcast their breast cancer surgery, they webcast professional events, they webcast everything from grandpa's 70th birthday, to a speech they gave at a university. And then, of course, there's YouTube, an amazing resource. But let's face it, some of the content on YouTube is really quite trivial. But people think that every forgettable moment of their life needs to be filmed, uploaded, and shared. I have teenagers. I have one teenager now, one son who's 21, and they were very upset with me when I didn't initially resisted being available to them 24/7 on my smartphone. But Mom, I texted you. Why didn't you answer my text? He texted you. They were baffled. Because today, a mom who doesn't video chat is like a mom who doesn't cook. You're worthless, right? But it's not just teenagers who have embraced the ethos of revelation. Earlier this year, I was visiting a museum with my 50-year-old brother, a lawyer, worked for Microsoft. While we were in the museum, he took time to update his status on Facebook. He let hundreds of friends and acquaintances know where he was and what he was doing. Far from home, he used the Foursquare application to let people know where he was and to find out whether anybody else he knew might happen to be in the same place. It's not evil, right? But it's an interesting way to live in the world, to live in a world in which you're constantly sharing everything about you with other people, or lots about you with other people. We're curious, we're inquisitive, we're accountable. And I kind of get the frame of mind that Darun Ravi, the young man at Rutgers who webcasts his roommates' intimacies, I kind of get his frame of mind. He's thinking, well, it's my room, right? It's my camera. Everybody knows that people have web cameras. And he was kissing the guy, right? It happened, didn't it? So all that context in this person's mind justifies the prank, right? Because it's, we all know the game, the rules of the game. That people around us may have cameras or webcams, and we might get pranked, we might get caught. And it's funny, it's not criminal, but it was criminal. It was criminal under New Jersey law. So, how do you, I gave you a long sort of laundry list of philosophical lines of thinking about why we should be concerned about privacy, but I sometimes find I need to go way back in time to another era in order to find a discourse for articulating in a way that people readily understand what's at stake with privacy. I go back 200 years and I go back 2,000 years. First, my 200-year example. So consider the entry in the diary of John Adams, dated August 20th, 1770. Adams was a patriot of the American Revolution, of course, and eventually a U.S. president. In Adams' view, privacies of concealment, secrecy, and reserve are both moral virtues and moral duties. Worldly wisdom dictates that we protect ourselves, he said, from, quote, damage, danger, and confusion, unquote, by generally keeping, quote, our sentiments, actions, desires, and resolutions to ourselves. He said our enemies and our friends are to be worried about. Enemies and indiscreet friends alike risk loss, these are his words, loss, disgrace, mortification. On occasion, he did note we have an obligation to not keep our thoughts to ourselves, and I think he thought in particular that in times of political crisis, it might be our obligation to share our position on some political matter boldly and publicly. But I was very taken by finding this diary entry in which someone was giving a utilitarian argument for privacy, but also claiming that we're better people, sort of from a character point of view, if we are discreet and reserved. Okay, we're more dignified if we adopt that behavior. Okay? So another kind of rationale, less utilitarian rationale, comes from my 2,000-year-old source, which is the good old Bible. Okay? Book of Matthew has this amazing discussion about privacies in connection with piety. And in this passage I want to talk to you about, the argument is made that pious acts such as giving to the poor, praying, and fasting are undermined by intentionally seeking public notice. Modesty and reserve are defended, and the idea of taking, as it were, God alone in our confidence. And I think that you don't even have to be the least bit religious to get the point that I think is both a religious and a secular point about the value of not being a show-off, right? The value of not putting yourself on display. So there's in this book, in this Matthew, there's an argument that we should be modest in our almsgiving. So the passage reads, when you give alms, don't sound a trumpet. So when you give to charity, I just gave $1,000 to, the Red Cross, all right? Don't do that. That's what hypocrites do. When you give alms, do not let your left hand know what your right hand is doing, so your alms will be done in secret, and your Father who sees in secret will reward you. And I interpret this as saying, basically, there are intrinsic goods that come from giving, and you don't need to give in a public, ostentatious way in order to receive the true reward of this kind of conduct. Same thing concerning prayer. Matthew reads, when you pray, don't be like the hypocrites. They love to stand and pray on the street corners to be seen by other people, but they've received their reward, etc., etc., etc. Go into your room and shut yourself up. Pray to your Father who's in secret. Your Father who sees you in secret will reward you. And then finally, concerning fasting, this is my favorite one. When you fast, do not look dismal like the hypocrites. When you fast, put oil on your head and wash your face, so your fasting may be seen not by others, but only by your Father who is in secret. So, clearly there's something in our Western tradition, our Judeo-Christian tradition, and in our political tradition that says privacy is important. It's important to protect, it's important for a society, it's important for you as an individual. You as an individual have a reason to protect your privacy because doing so enhances your dignity, protects you from harm, and ultimately rewards your character. Okay? I think that's pretty good stuff. But what about the law? How does the law relate to this discussion about not giving away your privacy and not having others take it away. Well, I think the law is primarily going to help us with the great privacy takeaway and not with the giveaway. The giveaway, we've got to do it ourselves. The takeaway, maybe the law can help. So I'm going to remind you that we have this tradition of privacy in our law. My privacy law casebook, which Radine mentioned, is now like 1,200 pages long. It's so much privacy law. There's common law privacy doctrine. There's constitutional privacy law. There's regulations under many, many statutes. It's a lot of law. But it all began with the man on the slide, Louis Brandeis, who was one of the great Supreme Court justices and the key architect of our right to privacy. At law school at Harvard, Louis Brandeis formed a friendship with a man named Samuel Warren, who was a Boston Brahmin, and he founded a very successful law practice. Warren was annoyed by all the publicity going to his extravagant life, and so he convinced the brilliant Brandeis to write an article to be published under both their names, calling for the creation of a new legal right called the right to privacy. And this right would protect them against the tabloids and against so-called yellow journalism. So this article that Brandeis and Warren wrote was published under the title of The Right to Privacy in 1890, and it had a tremendous impact on the common law. When Brandeis left law practice and went off to become a Supreme Court justice, he took his commitment to privacy with him, and he took this idea that privacy rights are inviolate with him. In a famous case called the Olmstead decision, Brandeis dissented from a decision saying that government did not need a search warrant to bug a house, bug a house through the outside. Brandeis argued, by contrast, that wiretapping is offensive without a warrant. The Fourth Amendment ought to come into play because the right to privacy, the right to be let alone, is, quote, the most comprehensive of rights and the right most valued by civilized men. And today, the privacy right is well established as a constitutional value in interpretations of the First, the Third, the Fourth, the Fifth, and the 14th Amendments. So I mentioned privacy statutes. The list of privacy statutes is very long now. We have the Privacy Act, the Family Education Privacy Act. This is the one that protects your academic records from disclosure. We have the Electronic Communications Privacy Act, protecting our telephone calls and our email and our GPS. We have a lot of statutes. Our video rentals are protected by a particular statute. Children under the age of 13 are protected by a COPA statute that makes it unlawful for website operators to collect personal data from children under 13. So we have a lot of privacy law. My view is we don't have enough privacy law because we don't have privacy laws that are as up to date as they should be. Our communications laws, for example, were written in 1986. That's before most people used computers on a daily basis, before people had cell phones in their pockets, before the internet, before the web, and they had rudimentary versions of those things. But before this ethos of revelation and the attractiveness of the internet was a foundation of our very daily existence. So they need to be updated. The Patriot Act did update our privacy laws, mostly in the direction of strengthening the government's ability to get access to people and our personal data. So there's a movement afoot. There are bills in Congress now to modify our privacy laws to give us stronger rights against having people, for example, get access to our cell tower records from our cell phones without a warrant, or other GPS searches and so forth. So we need some updating. There are just amazingly shocking things happening all around us, having to do with the lack of regard for privacy and sort of underscoring why we need to have stronger laws and stronger ethics. The case I want to mention briefly is a case called Yat versus Fairview Clinic, in which a woman brought a suit against a medical facility and members of her family. What you see on the screen is an electronic medical record. Well, this woman went to the doctor. She was having an affair. She had an STD. She went to the doctor for treatment. And, she got the proper treatment. Well, someone who was a member of her husband's family who worked in the hospital happened to see her in the hospital and thought, what's Candace doing here? So she used her ability to access the medical records, because she worked there, and she accessed Candace's medical records. And when she saw that she had an affair and had an STD, she then called other relatives. And pretty soon, the information got back to Candace's husband, who promptly began to divorce her. But that's not the worst of what happened. The worst thing that happened, arguably, was that the family put up a MySpace page called Rotten Candy, in which she was condemned as a dirty person, an adulteress, and oddly that she was addicted to plastic surgery. I don't know where that came from, but it was the family put up this website. So Candace has to sue her own in-laws, right, for invasion of privacy. And one of the issues that arose in the case was whether, if someone puts up a MySpace page, or a Facebook page for that matter, and we don't know exactly how many people ever saw it, is that an invasion of privacy? Because you have to publish something, right? And I like the fact that this court found that putting up a MySpace page, even if you don't know exactly who saw it, is equivalent to announcing something on the radio. You've published, and so the person who does it is liable for any invasions of privacy or defamation which may have occurred. In my own community of Lower Merion, Pennsylvania, we had a notorious case a couple of years ago involving the high school that my daughter attends. This is a young man named Blake Robbins. Blake Robbins was called into the vice principal's office in 2009, November, and she told him that the school believed he was engaged in improper behavior in his own home. And he says, well, how do you know what I'm doing in my own home? And she says, well, as you know, the school has issued you a Macintosh laptop, and we have remotely activated the webcam. And so we have been observing you, and we believe that you are using drugs at home. Now, Robbins claimed that he was just eating Ike and Mike candies and not taking some horrible drug, and it was a mistake. Well, when his parents found out about this webcam activation, and when the community found out about the webcam imagine, because thousands of children in this school district are given free laptop computers, which they're required to use at school, and they're allowed to take home. All high school students are issued a laptop when they become freshmen. So all these children's webcams could be remotely activated by the school district at will. And the argument the school district made was that, well, we have this webcam program, it's an anti-theft program. And we didn't tell people about it because, of course, if you tell them about it, they might find ways to thwart it. They might put tape over the webcam, or they might, So we didn't announce this generally, that we have this program. And the school argued that it was a way to help them find cameras. Stolen laptops. So if they knew who had the laptop, they could, send the police to that person's house and recover the laptop. Unsurprisingly, when this case went to court, which it did, there was a relatively prompt settlement. The school settled with the Robbins boy for $610,000, and they agreed never again to use the tracking software on school-issued laptops without the consent of the student and their parents. To me, the fact that the school district would think it was okay to do this shows how great the ethos of Revelation is. People think that disclosure is a good, and that we should be able to reap the benefits of disclosure. People don't have any strong privacy interests or needs that are stronger than the need to keep track of property, or to enforce the law, or to help children with their drug problems, alleged drug problems. And by the way, gossip has it that this boy was using drugs, actually, and that the school had reasons for being concerned about him. But that's not the school's job, right, to co-parent the children by looking at what the child's doing after school hours and then, taking action. Not a very happy-looking fellow. This is John Locke, the philosopher. He looks so unhappy, doesn't he? He is an important thinker for me in this tradition of Western philosophy about privacy, because he was, a social contract theorist, and he endorsed the idea that we should have a government of laws, civil society in which individuals had very strong personal rights. But he also emphasized that we are social beings, and that we have to expect a certain amount of disclosure and community as part of living in a civil society. But Locke, the natural rights, natural law contractarian, arguably, was not anti-privacy, and his vision of privacy has affected our thinking about privacy. This slide shows a newspaper ad that was published in the Atlanta Constitution back in 2004 actually. And the ad shows a man, the stout man, his name is Mr. Pavsich, Mr. Paolo Pavsich. Mr. Pavsich had nothing to do with the New England Life Insurance Company. He'd never bought insurance. But they got a picture of him from a photographer, and they put his picture in this ad, claiming that the reason why he was not scrawny and unhappy like the other guy is because he had bought life insurance from the New England Life Insurance Company. Right? So Mr. Pavsich, who was sued for invasion of privacy, and while some other courts had been reluctant to find judicially a right to privacy, the Supreme Court of Georgia became, in 1905, the first state Supreme Court to recognize a right of privacy, and they applied that right to Mr. Pavsich's case. But what is most interesting about this case, and I have an article about this coming out in the Fordham Law Review, is the natural law argument that the judge made as to why we have a right to privacy, because nobody would agree to join the social contract if the government, so formed, was not going to protect their interest in privacy. Privacy is a deep natural interest and natural right that we all have. And that was the reason why the court found that even though the legislature had not yet recognized the right, and even though common law had not yet fully recognized the right, they could recognize the right, because any rational being could understand the importance of privacy to the life that we are set upon to live. We're free. And in the most striking part of the opinion in Pavsich, the court compares privacy rights to being free from slavery. The court analogizes someone whose privacy has been invaded to someone who's been enslaved, who's master to somebody else. Someone else controls their life, drags them out of their own home, as it were, and thrusts them into the public sphere. And in my Fordham article, I question whether this is a hyperbole, whether invasions of privacy are really like slavery. But I kind of get what the judge was trying to say. He was trying to say in a very strong way that when other people invade our privacy, they are controlling our lives. They are subordinating us. And as free citizens, we should not have to deal with those kinds of unwanted interferences. This happier philosopher is Jean-Jacques Rousseau, the 18th century French philosopher, another social contract theorist, who wrote about the way in which civil society emerges. And in his view, privacy is sort of the natural state of things. We're not naturally social the way some social contractarians provide, but rather we are forced together by need. To live in communities, neighborhoods, and we sort of became neighborhoods of hut dwellers from a context of complete freedom as unself-conscious, solitary animals. He even argues that women are not by nature communal, that in a state of nature, women abandon their children as soon as they can, get rid of those little things to live their solitary lives, right? And he argued that once we had to become communal to deal with our practicalities, that we became conscious about how we're going to achieve sanctuary, secrecy, and control over ourselves. How do we deal with the jealousy, the ambition, the competition that humankind comes upon when they have to live in communities? But what I really found interesting about Rousseau is his insistence that enjoying privacy is a fundamental sort of condition of humankind. And we don't literally believe in social contract theory, right? But it's a metaphor for civilization's emergence from a domain in which there is no rule of law. But it's striking to me that philosopher after philosopher is aware of the importance of some rules of propriety and rules of conduct that separate one from another. Not because we want to be individualistic and not care, but because we need that in order to pursue this essence we call personhood. Privacy can be Machiavellian, even antisocial, but doesn't have to be. It can just simply be a sanctuary. So, what do we have to hide? What must we hide? This is a slide which shows one of the many surveillance cameras that are erected on lampposts in Washington, D.C. and New York City. I don't know if Miami. Does Miami have a street camera program? Yeah, okay. So we're being observed. What should we try to hide? Well, I think we should try to hide what's necessary to preserve our common dignity and separate virtues. We should hide what's necessary to keep ourselves safe from harm. We should hide what our roles and responsibilities and professions dictate that we hide. As doctors hide patient confidentiality, so do lawyers. And we should hide, notwithstanding all of technology's attractions, we should hide what we need to for good relationships and good reputations. And not just now, but also in our futures. If you post everything on Facebook, it's kind of like getting a tattoo on your face, because it's something which you can't remove. It's there forever. There's no take back. There's no right of take back. In fact, one legal innovation which I would like to see occur would be rights of us to recapture data by taking down our Facebook pages or our Twitter messages at will. But so far, the courts are going the opposite way. If it's there, it's available to the public and to the justice system for any variety of purposes. Telling us exactly what to hide and why, this is the work, I believe, of a comprehensive ethic of privacy in the era of revelation. My most recent book, and I will end shortly, but I want to just tell you, I do explore in more detail my vision of why I think we need to be concerned about the loss of privacy. And I create a concept called unpopular privacy. It's a privacy that we're all giving away, right, that we're all indifferent to. And I make an argument that in a just liberal society, there could be both ethical and legal rules that require us to embrace and accept unpopular forms of privacy. In my book, I talk about privacy in many different contexts, including the concept of racial privacy, which has been a big issue in California, about confidentiality for professionals like lawyers and doctors. I talk about the significance of the wearing of the hijab and the niqab in American society, and about how the law, on the one hand, wants to keep us want to encourage women to be more modest, but at the same time, if we're too modest, we also create problems in our society. I talk about prisons and other modes of confinement that keep people out of the public light. So in this book, I use a lot of different kinds of examples to shine the light on this question of what kinds of privacy should we be preserving and which types should we be allowed to let go. I argue for a position that's sometimes called privacy paternalism. Why would we be tempted to have a paternalistic stance on privacy, to force people to embrace privacy they don't actually want? Well, I think because of the consequences of serious harm. A lot of young people, like children, don't quite understand the implications of publicity for future education, future employment, careers. We've had students at Penn lose clerkships over things posted online. Identity theft, stalking, exploitation, advantage taking, all this comes from too much disclosure about which people may not be appropriately sensitive. I think because of the complexity and novelty of technology, we don't really know how to protect our privacy. And there's a lot of false advertising on Google and other websites about the use of privacy controls. There's a lot of so-called anonymization, but de-anonymization is also possible, and data aggregation, data mining, and matching. So I believe there are many reasons why we should think that we shouldn't leave privacy choices solely to the individual or to the firm, but we should be involved as a culture and as a society in what's happening with our privacy. And maybe the kind of norms we've used in the past, like fair information practices, that's the FIP, privacy by design, and generally accepted privacy principles, these sort of norms that a lot of businesses are embracing may not be enough to really get the privacy protection that we actually need. So, in conclusion, I would just urge that we spend, as individuals, a bit more time thinking about the ethics of a giveaway. Zip it up. Be a bit more careful in the disclosure of your secrets. And then we also need to be very aware of the takeaway, the ways in which the government and the business sector, big business and Big Brother, are threatening our everyday privacy. Keep those two things in mind, and let's see what happens in the future. Thank you.
Professor Allen is willing to take questions, and I believe we have a microphone to use for that purpose. And before we get into the questions, it is my pleasure to present on behalf of the St. Thomas Law community this plaque commemorating Professor Allen's service as our distinguished lecturer in law. Thank you.
Thank you. I would love to have some questions or comments. Don't be shy. Yes, sir.
Okay, so Facebook is obviously, you voluntarily put your life to the public, right? You voluntarily open your life. But isn't it kind of a right to keep your life, whatever Facebook, your personal life, separate from the business sector? I don't really agree with how businesses are kind of rejecting kids because, or adults because of their Facebook profiles. Isn't your personal life, shouldn't it, if it doesn't affect your business life, shouldn't it be private? Shouldn't
Good.
it be separate? Like, shouldn't it be considered a separate entity?
Good. And you're not the only person who's raised this question, right? A lot of people, especially younger people, have argued that it should be prohibited for employers to mine data from your Facebook and then use it as a criteria for hiring you or not hiring you. You should be able to keep that stuff private. There should be a line there that you don't cross. It should be a legal line or at least maybe a policy line. That we just don't do that. We don't do that to people. But as you know, that's not the thinking that has emerged. What's thinking that's emerged, on the contrary, is that it's out there. If it's public, it's public, and if it's private, it could be subpoenaed anyway. So what I think the question suggests is that there was actually an expectation, I think, among the first generation of Facebook users that this would be a private space defined by the Facebook user. Right? By embracing certain people as your friends and rejecting others, you would create a domain that would be, in some sense, confidential to that group of friends, even if it didn't have the official status of private or secret page. But the culture arose around Facebook of advantage taking. So not only do you have the public have access to your data to judge you based on, I don't like his clothes, he parties too much, swimsuit too revealing. I don't like her religion. That kind of thing can be used against you. But not only that, but also we have all the advertising going on now too, where what you post on Facebook might result in certain advertising coming at you, about products and services that you might be interested in, which is for some people another kind of invasion of privacy happening online. So I get your point. It shows that we could have gone a different way. We could have deemed a barrier there, but didn't happen that way. And I don't think there's any likelihood that schools and employers are going to be prohibited from seeing Facebook. So we advise everybody, be careful. Don't post anything you wouldn't want Justice Scalia to see.
Other questions? Here, let's go in the back row.
Yes, ma'am. Oh, okay.
Wait for the mic.
Okay.
For a little while, I saw people posting on Facebook like some type of notice that everything that they posted was to be private. I saw people continuously posting it, saying that Facebook had made some type of announcement that if you posted this publicly to people that are seeing your page, it would constitute some type of right for you to maintain that private. And if somebody went against those wishes that you posted, you had some type of legal basis to seek damages or anything like that. Do you know if that's true?
It's not true. I mean, what is true is that a social network provider like Facebook or Twitter has tremendous power to set the rules of the game. When's the last time you actually read the Facebook privacy policy? Probably most people have never read it, right? My family has a secret Facebook page that only members of my siblings and our children have access to on Facebook, and we share family information. But I know that if one of my nieces or nephews were involved in a drug violation, that page might be subpoenaed. I mean, and I know. So and Facebook can't help you there. And Facebook can try to have a responsible privacy policy, but Facebook has a lot of financial incentives to bring in revenue through advertising, and a lot of incentive to make it a safe space for you, but they can't control their own interest in not being punished by the government for not allowing outside access is a huge business problem, right? And recently Twitter was forced to give over the tweets of a person who had, even though they had promised privacy, they initially said, we're not going to we're going to side with the user. They eventually caved. Why? Because it's a big financial problem for these companies if they end up having to litigate case after case of unwanted disclosure demands from outsiders for tweets. And it's not just the government for governmental purposes, but in a private lawsuit, someone could subpoena your social networking post, and they might be available for that lawsuit. So what you heard is not exactly true. I mean, there's a lot of urban legends, right? Because we want to believe that somehow our privacy will be protected. But I would just assume that everything I post on Facebook can be either seen or obtained relatively easily by third parties. So be careful. Yes. Yes. Oh, I guess the mic is. I'm not controlling the mic, so. For posterity, the benefit of posterity, you must use the mic.
Yeah, I will let you know in terms of privacy that this is being recorded.
And that announcement lawfully should have been made at the beginning of. And I should have signed a waiver, right? I didn't sign a waiver. Did I? Maybe I did sign a waiver. Yes, sir.
To go off what Zach was saying, what you just said about assuming everything we post can be used in courts or in public, well, he was specifically talking about separating business use of our Facebook pages. Do you think our generation, do you envision like a shift of change that by the time we're in control of businesses or government or whatever, that we will separate those two entities, like your Facebook private life and what you do in the business sphere?
Well, certainly your generation has the option of changing the policies of educational institutions, law firms, and employers, business employers, right? You could adopt. Suppose you were to become a partner in a law firm in Miami in 4 years. Well, you could certainly say, well, our law firm will adopt the policy of not going to Facebook or any other social media to Google potential employees. We won't do that. I mean, you could do that. I'm not so clear, though, that you would have the ability to create a legal right on the part of social network users to not have employers access. But there's something the closest thing to it we've already got is that health insurers and employers are not permitted to use our genetic information, right? So there's a case where the information exists and it's deemed sensitive, and the law, it's called the Genetic Information Non-Discrimination Act, it was passed about 3 years ago. This law prohibits health insurers from finding out that we have a genetic condition that might bear on our health. It prohibits employers from finding out that we may have a condition, and it prohibits them from, if they do find out, from using the information to make decisions about employment. So maybe there is kind of a model out there for what you're describing, right? A law, but we'd have to. But in the case of genetic information, think of how extra sensitive, right, the genome is in the popular mind and in the mind of Congress. And will Congress, your generation's Congress, ever see the kinds of things we post on Facebook as being as sensitive and as demanding of protection from employers or insurance companies as we now see genetic information? And actually, I think that while GINA is an important law and will have longevity, there is a movement among some patient advocacy groups and some researchers to request that people not treat their genetic information as private. Why? Because if more of us will have our genes sequenced and share that data with researchers, we'll more quickly find the cures perhaps to important diseases and conditions. So sharing would be beneficial. And I'm curious to see what happens to GINA in what I think is the emerging world in which there's so much pressure for the public health benefit to share even this highly sensitive kind of information with if not employers, at least with researchers. So I think there is a model for what you're describing, and you have the potential to adopt policies and to push for laws that would be based on that model.
One other question? Here you go. Take it.
Professor Allen, I wanted to thank you for speaking with us today. My question was about in our generation today, or not our generation rather, but the younger generation that's grown up with almost unfettered access to everything. And what ways would you propose strategies that we could sort of wean them off of that access into, because I agree that that more privacy is needed, but I believe with the younger generation that they've grown up their entire lives with this much access, and traditionally people are much less willing to restrict their access rather than expand their access. So I was wondering what strategies you had.
So interesting. So old-fashioned parents had to teach their children how to study for their exams, and how to restrain their violent impulses, and how to keep their rooms tidy and brush their teeth. Today's parents, I believe, have an obligation to teach their children how to enjoy time offline. So I give you a personal example. I was invited to teach in Japan, in Tokyo, a few years ago, and I took my daughter, who was at the time a middle schooler, and for several weeks she had no access to any technology. Not her cell phone, not her laptop, nothing. And guess what? She grew to love reading. You know, when she went to bookstores, she bought piles of books, and for the first time in her life, she started reading books. So I think that not that everyone can go to Japan, but wherever you are, I think you can perhaps have model offline behavior that's fun and exciting and enjoyable, and then also sometimes insist that children unplug the phone, unplug the iPad, unplug the laptop, and so on. But it is a kind of parenting. I'm interpreting your question on that level. And then, of course, schools and other institutions can have a role as well. But think about it. I mean, I just told you about my children's school district, which is like many school districts, which are giving children laptops, and they are expecting them to educate themselves and participate in schooling through technology. So there are these counter, that we're pulling. We understand the importance of developing the virtues of solitude, tranquility, repose, creativity, independence that come from not being online. But at the same time, we recognize the value of using computers to further basic educational goals. Can we have one professor?
One professor.
One professor. Don't make it too hard, though. Okay.
No. Actually, I'm puzzled because you mentioned Locke and Rousseau, and I guess one of the underlying issues would then be, according to you, is a question whether privacy is a natural right as opposed to socially or a man-given right.
Yes.
And if that is a question, what would be your answer? First of all, at the philosophical level and at the real level. And if the answer is that it's a socially given right, then to whom do we trust those decisions that you're suggesting, those changes?
So in my book, I argue that privacy is what I call a foundational good. It's a good that is important because it's a means to other goods. So if we, I believe that, for example, privacy is a mechanism, this is the utilitarian dimension, a mechanism for developing and protecting talents and skills and the kind of independence of thought that enable one to exercise autonomy in a meaningful way. So if you value independent thinking, moral autonomy, then you have a reason to think that, well, we must give people quite literally the space and metaphorically the opportunity to develop in context of privacy. So while I don't necessarily use the language of natural rights, I think the natural rights tradition is useful for illuminating why it is that we so value our liberal values, our values of autonomy and independence and freedom from domination. And to the extent that we can link opportunities for privacy with that kind of freedom, that we see so often praised and developed in our natural rights and contractarian traditions, I think that we're on the right track. So in my forthcoming article in the Fordham Law Review, I do say that while the natural law discourse is very problematic, especially in traditional times where we're no longer St. Augustine, we're no longer so comfortable with that discourse, especially not in our courts, but we are in our courts, I believe, quite comfortable with the idea that, that we should be free from undue governmental interference, and also free from undue interference from our fellows. And again, that the right becomes sort of foundational to the extent we can link it to important modes of liberty. Now, I happen to think, for example, that maybe it's an overkill to say that publishing your picture without your permission violates a natural right, just that little act. But I think that if we live in a world in which we have surveillance cameras everywhere, in our homes, in our schools, and on the streets, and people are unable to express themselves as individuals, that we have a problem that does go to the foundational values that underlie what I would call the liberal and democratic way of life. So I think that's the kind of move I try to make, to link privacy to these basic kinds of goods that philosophers from John Rawls back to the earlier contractarians have tried to articulate.
How about another round of applause for Dr. Allen?
Thank you.
Thank you. Thank you all for coming.